All right, ladies and gentlemen, good morning. These are our magistrate arraignments for Denton County for Denton County Jail for Friday, the 5th of November, 2021. We're on the record. I tell you that for a couple of reasons. First of all, just to make you aware that it is a recorded proceeding, but probably more importantly for our purposes today, since it is a recorded proceeding, you still want to be careful what you say because someone could pull this record, and if you make some statement that's incriminating, it could be used against you later on. So part of my job as judge and magistrate for Denton County is to meet with people in most days to tell them of what they've been charged, their rights, and their bond amounts. Bond, of course, is a set of conditions or requirements that you do something or check in with someone on it in certain cases, although not in most. In fact, I don't think we have anyone here today that have any particular conditions of bond. But more typically, it is an amount of money that you would need to post for the court or promise to pay to the court in the event that you fail to appear for court or fail to abide by some other condition or term of your bond. Bond can be posted in full, in cash, if you have that kind of money. Most people do not, so they go through a bondsman. But if you could afford to put the money up in full, in cash, in the long run, you probably save a little bit of money, because then when you come back to court, you'll get to pile that money toward the fine. If you were found guilty, or if you're found not guilty, the case dismissed, you would get all that cash back. But again, that's only when you post the money in full in cash. If you cannot afford to do that, though, you can go through a bondsman. Bondsmen charge percentages, typically between 10 and 25% of the total amount of money that I tell you, but it really depends on whatever you can work out with a bondsman. Different bondsmen do charge different rates. So what you might want to do is call a friend or family member, tell them you're in the Denton County Jail, how much bond's going to be, and let them work on trying to get you out. Now, you might be in the room with someone else, have the exact same charge, and still have a different bond amount. That is because we're trying to use risk assessment, looks at some information other than just the charge for which you've been arrested, looks at ties to community stability, and probably more importantly, criminal history and whether or not you're currently out on bond. So if those are conditions or issues, then the bond would be higher than someone in the room that has the same charge but does not have that background. Other than that, so each of you here absolutely have constitutional rights. You have the right to remain silent. You do not have to talk to the police or anyone representing the state at all, because anything you say can and probably will be used against you later on. So you still want to be careful what you say. And while it's unusual to see the police departments or agencies want to come down here and talk to you after an arrest, they could. And if they do want to talk to you, you can talk to them if you want to, although I just advise you of your right to remain silent. But if you give up that right and start to make a statement, you can always stop or terminate that interview at any time. Just because you begin doesn't mean you have to continue to talk. You have the right to speak with an attorney, to have an attorney present during any questioning, and have the attorney represent you at trial. And if you cannot afford to hire your own attorney, Denton County will appoint and pay for an attorney for you, or if it's a warrant from a different county, that county will appoint and pay for an attorney for you so long as you're truly indigent. Indigence, more than just that it will be difficult for you to hire an attorney, means that you simply have no resources to hire an attorney and that you won't be able to afford to hire an attorney at any point. So if you think that you're claiming to be indigent, if you indicate that on this form here today, it'll have you check or put your initials in the appropriate box. That will begin our process to get you a court-appointed attorney. Typically, we're going to have you fill out a sworn affidavit. That affidavit contains some questions about your financial resources, assets, and job. Fill it out completely and fully, showing that you are, in fact, too poor to afford an attorney. We're going to process that information. And if the county determines that you're indigent based on the information you provide, then Denton County will appoint or assign you a court-appointed attorney. Make sure that you fill it out completely and fully, because it is a sworn document, but we'll review that information and perhaps appoint you an attorney. Although you normally won't be talking to a court-appointed attorney for another 2 or 3 days after date of appointment. Since today's Friday, it might even be Tuesday or Wednesday of next week before you hear from a court-appointed attorney if you're given one after claiming indigency. If you're here on a warrant from a different county and you're claiming to be indigent, we'll notify that county electronically that you're asking for a court-appointed attorney. They'll begin to get their process started. Sometimes actually send us a request for some additional information, but they'll start their process. And even if they do appoint you an attorney, you normally don't talk to that attorney until you've been transferred into their custody. Although with HomeWave and some other processes, they might contact you directly while you're here. And if you bond out from here, you can go see your court-appointed attorney from a different county when you get out. If you're here for a felony grade offense and you're unable to post your bond after a reasonable period of time, you can also ask the court to release you without posting bond at an examining trial. It's really kind of a legal process that typically applies only to felonies, only when you have been able to post your bond, and only when there has not been a grand jury indictment returned against you first. If you're here on a charge, in certain cases, and the case still has not been presented or filed with the district attorney's office within a certain period of time, then Denton County will set you up for a release on a personal bond. If you're here for 15 days or more on a Class B misdemeanor, 30 days on a Class A misdemeanor, or 90 days on a felony, then you'd probably be released on a personal bond, but that does mean that you still have to come back for court when you're notified to do so. And again, those only apply when the case has not been filed or state does not announce ready within 15, 30, or 90 days. Last but certainly most importantly, you absolutely still have the right to a trial by judge or jury. Just because you've been arrested and charged doesn't mean you're guilty of anything. In fact, the majority of these cases this morning, the cases have still not even been filed with the district attorney's office. So you certainly have a right to a trial by judge or jury. The only exception to that is if you're here on probation violation. I think we actually have one parole case here as well. So on those, you don't have a right to a trial by judge or jury on the underlying charge, but you do still have a right to a hearing to determine whether or not you violated some term or condition of your bond or of your probation. I'm sorry. So let me start off with Richard Hill. Mr. Hill, come on up. Mr. Hill, I have you here on 2/17, 16, 17, 19. Those are not new cases. They're old cases, cases that are out of Denton County. So they're in addition to your cases that you have out of Dallas. Those are Dallas PD. So apparently it might just be bonds that you set on these new cases. At any rate, charge of terroristic threat causing fear of serious bodily injury, warrant MC 2109943. Again, it's a Denton County case. Had a bond at $1,500. It's now $1,517.16. So it is bondable again. You just have to post a new bond on the same case you already paid a bonds before once. This is where your bondsman actually went off your bond. Charge of terroristic threat causing fear of serious bodily injury, MC 2109944 at $1,517.16. So you have I guess it's $3,000, a little bit over $3,000 in Denton County cases, and wow, Dallas PD cases. 50,000, 50,000, 50,000. Wow. So I think we've appointed John Rentz to represent you on this. Have you had a chance to talk to your attorney about these?
Yes, sir. We've probably been putting in for a bond reduction.
Okay. Hopefully they'll get that set up. Yeah, those are high bonds. I can't even tell if they're filed cases. But hopefully we'll get you set up for a bond reduction, be able to get your bonds reduced on that. Yeah, they're all three stalking cases. Again, I can't tell if they're filed or not. F21.
I haven't been indicted on anything else.
Huh. Okay, well, they're not my warrants, so I don't, yeah, hopefully we'll get those bonds reduced for you. So without saying you agree with or admit guilt, just so you understand your rights, your charges, and your bond. These again are not new cases. They're old cases. You paid the bonds for once, but now your bondsman's taking your money, gone home, okay? So let me get your signature on this form, just so you understand that. At least we can try to get you some credit on these at the same time. Talk to Mr. Rentz, and he'll see if he can't work these into some kind of a package deal when you go to court. And then since you have Mr. Rentz appointed, let me get your initials in that bottom box, the one right above your signature, saying you're claiming to be indigent. All right, thanks.
Make my bond higher?
Huh?
Just make my bond higher?
Well, it added $3,000 to it. So you had $150,000. So now it's $153,000. So it added $3,000 to your already. Those are very high bonds at $50,000 apiece. Wow. I'm not sure who set those bonds. I hope it wasn't me. At any rate.
That's why I got my bond set right here.
Did I set those bonds?
Yes, sir. I tried to talk to y'all about it then. Like they went down.
I'll have to go back and look at it, Richard, but I agree those are high. I will reconsider that. Have Mr. Ritz contact me. I'll be happy to look at those. I have to, again, the warrant numbers throwing me off. I can't tell much about them, so I'll have to go pull the actual information. But yeah, and you've been here since the 23rd. So yeah, we'll see if we can get those reconsidered for you.
Yes, sir.
Okay. All right. Thanks. Kristen Harrington. Hello, Ms. Harrington, one charge of criminal trespass out of Wise County. Cash only bond, Wise County warrant CR 80575-2. Bond's not extremely high. It's $1,202, kind of odd amount, but problem is it's a cash only bond. So only cash, can't go through a bondsman. Charge of failure to identify as a fugitive CR 2005 or 20577-2 at also out of Wise County at only $302 cash. So I guess that brings it up to $1,504, but cash only. So let's see, you don't have anything else out of Denton County, I don't think. So we'll notify Wise County to come pick you up as soon as we can. But just saying you understand rights, charge and bond, not saying you agree with or admit guilt. Let me get your signature on that line, just saying you do understand your rights, your charge, and your bond amount. And do you think that you can arrange, do you have someone who's going to bring you $1,500 in cash?
I'm supposed to be leaving for rehab though on Monday. Like I've had it set up and I just went to court on Tuesday
Here in Denton County?
in Wise County. So I don't know why they issued a warrant because I was just at court on Tuesday. And
That is odd. Yeah, I can't even tell. And those warrants were confirmed yesterday at 10:05 in the morning. That is odd.
Yeah, so I don't know what's going on, but I know that I've been trying to get into this rehab. I'm going to lose my spot.
But it was a rehab out of a case out of Wise County. Maybe it's a process to get you to that facility. I don't know.
It's for the same case. Like I just talked to them. My attorney was there and everything.
Try to call your attorney. They might just be trying to get you back so they can get you into the rehab. But let's get your initials in that bottom box saying you have a court-appointed counsel. Do you know your attorney's name?
Kathleen McGoggle, but she's not answering the phone. I tried to call her all day yesterday.
We will send notification electronically to see if she can contact you here, okay? All right. Thanks. Have a seat. Garrett Hedden. Let's see, Mr. Hedden, one charge, manufacture, delivery, controlled substance, pen group 2, over 1 gram, but under 4, but not a new case. It's a failure to appear, so it's out of Judge Shipman's court. Warrant F20 76216, so it is a no bond currently. Doesn't mean you can't get a bond set, but I can't touch it. Only Judge Shipman can change that for you. So if you have an attorney, you can ask them. Sorry?
I said, I'm sure I'll have good luck on that one. She likes me quite a lot.
I know, I've known Judge Shipman. First of all, she's she's a very good judge, and she's fair, but she doesn't cut slack when she thinks you don't show up. So yeah, I think you're probably right about that.
Yeah.
If there's any good news, maybe you can get some stuff behind you and get credit for your time. So
Yeah, I've been dealing with these charges for almost 3.5, 4 years. So
yeah, so maybe it's just best to get them out of the way and behind you.
right.
They came all the way down to Athens, Texas to get you. Yeah, I think they were probably upset with you. Yeah.
Yeah.
So let me get your signature there saying that you're glad to be back in Denton County.
I was so happy.
Yeah, I can tell. I can see you're excited about this process. And do you have an attorney, Garrett?
Yep.
Is it court appointed or one you hired?
What I hired,
Initials in the top box. Who's your attorney?
Mike Trainer. He's out
Okay.
in Dallas.
Yeah. See if Mr. Trainer can get hold of Judge Shipman. I don't know if he's going to be able to get you a bond set, but perhaps he can get you over the court a little bit faster. So call Mr. Trainer and see what you can do. So initials in that top box.
All right.
All right. Welcome home, Garrett.
Right.
Well, it's nice to be wanted, isn't it? Maybe not on warrant. Maybe not on warrant. Brittany Liesk. Ms. Liesk, you have one charge, possession controlled substance, pen group 1, over 4 grams, but under 200 grams, out of Cook County. Wow, they take that seriously there at $20,000 in bond, warrant CR 2100518. So it's bondable. You can bond out from here, be released from here, but eventually you'd have to show back up in Cook County. So it has a bond at $20,000. So if you could afford it through a bondsman, it'd probably cost you between $2,000 and $2,500. It would be in addition to your Cook County case MC 2104. That looks like the same charge.
So did they just raise my bond? Because I got a bond set here just like 4 days ago for it. Did they just raise my bond?
Yeah, you know what? Looks like it was indicted. I probably set that lower bond. And when it went through grand jury, they jacked it up. Because what it says is warrant CR 2100518, grand jury indictment, possession of controlled substance. So it sounds to me like they took my $5,000 bond and jacked it up to 20,000. But if there's anything good about this, I think it takes the place of that one that we talked about the other day. So in other words, I don't think it's in addition to, but I think it's in place of, but we'll have to confirm that. So sounds like they take that a little bit more seriously than I have, but let me get your signature on that form, just saying you understand rights, charge, and bond. Do you have a criminal history, Brittany?
Yes. This is my fourth one.
That would probably be why.
Yeah.
And then initials, do you need a court-appointed attorney at their expense? If so, initials in that bottom box. All right, well, tell them you're asking for an attorney and we will see if your attorney can contact you, okay? Leopoldo Rojas. Mr. Rojas, one charge. It is a parole violation. Kind of rare that they do this, but as of about 6 or 7 years ago, they either say bond eligible or not bond eligible. So I'm going to go ahead and set bond because yours is a bond eligible charge. Parole violation, Texas Pardons and Parole Board 10152021-088046110. So the longest warrant numbers I've ever heard of. The original charge apparently was a drug charge. So it is, they said bond eligible. So I'm going to set bond at $7,500 since it is a rarity to see a bond set on that. So $7,500 bond. Get you out of here, but eventually you have to deal with your parole officer, okay? So let me get your signature on that form saying that you understand your rights, your charge, and your bond. All right, so I guess, I guess we don't appoint you an attorney on these, but go ahead and put your initials in that bottom box saying you claim to be indigent. I don't know what that triggers with them. We don't appoint an attorney for it, but. All right, thanks. Kevin Torado. Mr. Toronto, one charge, possession controlled substance, finger group 2, over 1 gram, but under 4. It was apparently THC oil. So on that one, I set the bond only at $500. It is a felony charge though. So you do need to take it seriously. Let me just sum it up with you're in Texas. Do you understand what I mean by that? Apparently not. So also a charge of unlawfully carrying a weapon. It's fine to carry a weapon in Texas in a car unless you're in the commission of any other offense. So when you had the other substance or allegedly had the other substance, that would make the possession of the firearm illegal. So that has a bond at $2,500. So it's a total of $3,000 in bond. Bonds run you maybe $300 or $400 to get you out on that. Do you think that you can arrange for your bond, Kevin? Huh?
No.
No. All right. Well, do you understand all those rights I explained?
Yeah.
Okay. Quite the charmer there. So let me get your signature on that line saying you understand your rights, your charge, and your bond. Kevin, you take these things seriously. I'm getting the impression that you're not. So let me get your initials in the bottom box if you're not going to be able to get your bond posted and you cannot afford to hire an attorney. Kevin, how old are you?
17.
Are you in high school?
Yeah, yes.
Okay. Do you have parents around here that might try to help you out on bond?
Yeah, my dad, but I don't know his number. I can't get a hold of him.
Okay. Do you live with them?
Yes.
Okay. Um, is it in your cell phone? Is his number in your cell phone?
Yeah, but my phone was dead, and he was just, they was like, they was gonna charge my phone, but they didn't, so I couldn't get no numbers.
Yeah. Well, actually, you probably should, once you get out, try to memorize numbers that you really need, because you never know when you're going to need it. So at any rate, we will try to get you an attorney. In the meantime, try to post your bond, because Kevin, you could be here for quite some time if you don't. Okay? All right, have a seat.
Yes, come with me.
Kathleen Clark. Ms. Clark, one charge of driving while intoxicated out of Prosper Police Department, but it's going to be filed on the Denton County side. Bonds at $1,000, so bonds run you maybe $150 to $200. On average, it's about $175. Bonds with low credit and debit cards. So once you post it,
Debit and credit's okay.
to the bondsman, not to the county. The county can't transact those fees. But the bondsman will accept a credit card and they'll charge you about $175 to get you out.
Wait, so
Or if you had someone bring you $1,000 in cash, it would be like a cash deposit.
y'all only take cash?
Yes. To be honest, the credit card companies are not allowed to for bonds. There's apparently they deem that not to be a transaction they can handle because it's not a credit extension. So it's a credit card thing.
Okay.
But if you have a friend that can go get your card and get the $1,000 out, that's one way. Or they'll have to come up here and get your cards from you, or call a bondsman directly, tell them you have credit cards, and they'll be happy to come up here and run your card. Okay,
Okay, sounds good.
great. Then signature on that line saying you understand your rights, your charge, and your bond. And do you think that you can arrange for your bond once you get hold of your friends, your family, or your credit cards? Fantastic, great. Initials in the top box. All right, well then go call and see if someone really does love you enough to get you out of here, okay?
Sure, you have a great day.
You too, yeah.
No, thanks.
This is what my legal career has come to. That's great. Darren Whitney. Oh, Mr. Whitney, one charge, possess controlled substance, Penner Group 2, under 1 gram in amount. It was apparently a pill, a very small pill, but it was 0.47 of a gram. So it falls under one category, but still Penner Group 2 case. So bonds at $500. It is bondable. A bondsman will probably ring you about $100 to $125 to get you out.
Yes, sir.
Signature on that, huh?
I can pay it in full, cash to
The 500? Fantastic. Then initials and let me get your signature on that line, just saying you understand rights, charge, and bond.
Okay.
And then your initials in the top box saying you're not claiming to be indigent.
Thank you, Your Honor.
Sure, anytime, come on back. We're always open. Nagaris Johnson. Mr. Johnson is in charge of assault, family violence, so it does fall into the assault of offense category. So it has prohibition against PR bonds, and typically the bonds at $5,000 is a minimum. So I'm going to set it at that $5,000 amount. So you could either pay $5,000 in cash, or if you call a bondsman, they'll run you about $500 or $600 to get you out on bond. It really depends on the bondsman, whatever you can work out with them. So again, it's a charge of Class A assault causing bodily injury, family member. Without saying you agree with it, without admitting that it's true, just saying you understand that information. Let me get your signature on that line, just saying you do understand your rights, your charge, and your bond. And then your initials in the top box. If you're going to, do you think that you'll be able to afford to hire your own attorney or post your bond?
Yes.
Initials in the top box saying that you're not claiming to be indigent currently and that you're going to try to bond out. Now, they had asked for a protective order that would have kicked you out of your house. That bond, that request, though, I'm not going to grant the protective order because of the way that the case was written up. I'm not saying it's not valid. But I am going to warn you that if you go home and they're called out again and you're arrested, the bond will be so high, you will not be able to post your bond. Do you understand what I'm saying?
Sir, you have no idea. I will not be back in your court.
Fantastic. So I'm not going to do the protective order, just going to, and so there are no other conditions, don't have to wear a GPS monitor or anything else that we commonly do with assaultive offenses. Just make sure things are nice and peaceful when you go home, okay? So let me get your signature on that form, just saying you understand your rights, your charge, and your bond of $5,000. And did you give me your initials in the bottom box?
Yes. Top box.
Thanks.
Top box.
Top box, I'm sorry. Thanks. Whitney Mills. Hello, Ms. Mills. You have one charge of driving while intoxicated. First offense out of Lake Dallas Police Department. Bonds at $1,000. So bonds run you maybe $175, depending on the bondsman, whatever you can work out with them. So without saying you agree with it, and without saying that you admit that it's true, let me get your signature on that line, just saying you understand your one charge of driving while intoxicated, your bond at $1,000, and your rights. And Ms. Mills, do you think that you can arrange to hire your own attorney or post your bond?
Yes.
Initials in the top box saying you're not claiming to be indigent or asking for court appointing counsel currently. All right, thank you. Jimmy Jackson. Mr. Jackson, one charge of driving while intoxicated out of Pilot Point Police Department, Class B misdemeanor, first offense. So bonds at $1,000. So again, bonds running maybe 75 to 150, usually closer to the 150 or so. Actually, I'm sorry, about 175. So it's bondable though. So without saying you agree with it, just that your bond's at 1,000, your charge of driving while intoxicated, first offense, and your rights. Let me get your signature on that line, just saying you do understand that information. And do you think that you'll be able to make arrangements to hire your own attorney or post your bond, Mr. Jackson?
Yeah, I can post mine. I can have my life. I mean,
Okay, their initials in the top box saying you're not claiming to be indigent currently. Just make sure you take care of business when they notify you for court, okay? Emma Manning. Ms. Manning is charged of possession of marijuana under 2 ounces in amount. It was in the operation of a vehicle. So for that reason, the bond's a little bit higher at 1,000, but it's still bondable. It is possession of marijuana under 2 ounces amount, which makes it only a Class B misdemeanor. So bonds will run you maybe $175 to $200. Again, depends on the bondsman, whatever you can work out with them. Without saying you agree with it or that you admit that it's true, let me get your signature on that form, just saying you understand your rights, your charge of possession of marijuana, and your bond at 1,000. And if I could get your initials in the top box, saying that you are not claiming to be indigent and that you think you're going to be able to hire your own attorney and post your bond, initials in that top box. All right, hopefully you can get your bond posted and get out of here soon. And last, but certainly not least, Robert Shields. Mr. Shields, come on up. Mr. Shields, they have you here on 2 Denton County cases. One's a warrant case out of County Criminal Court number 1 for driving while intoxicated, second offense. Good news is, has a bond at $5,000, warrant CR 2021-01549A. So it does have a bond. And you can go through a bondsman on that. So I say $500 or $600 for that. And then you also have a new case of driving, unlawfully carrying a weapon with a felony conviction, previous felony conviction. So it has a bond at $10,000, and that can be either surety or cash bond as well. So it brings your Denton County cases up to $15,000 in bond. But you also have a charge out of Tarrant County for assault, family violence with a previous conviction out of Tarrant County warrant 1621004D or 1D. That bond must be set by a Tarrant County magistrate. I'm not sure I agree with their authority on that, but they have indicated on their teletype that bond to be set only by a Tarrant County magistrate. So if I set a bond, you try to post it, they wouldn't accept it. So do you have an attorney in your Tarrant County case?
Not right now, I don't.
Are you gonna be able to hire an attorney to take care of that?
No.
All right, then let's get your initials in that bottom box saying you're claimed to be indigent, and Denton County try to get you a court-appointed attorney on our cases. We'll notify Tarrant County to try to get you an attorney on their case. And then your signature on that line, just saying you understand your rights, your charge, and your bond.
Hey, I got a question about my firearm case. Is that a felony or a misdemeanor?
Which one?
A firearm case out of Denton County.
The one out of Denton County, that's gonna be felony grade offense.
That's a felony?
Yeah, because it's with a felony with a previous conviction, yeah, previous felony conviction. So yes, it's a second-degree felony.
Thank you.
Sure, anytime. All right, folks, go call family, friends, see what you can do to get your bonds posted, and we'll start trying to get your court-appointed attorneys for those people who asked.